Right now from Judicial Watch, Mr. Tom Fitton joins us. Tom, good evening to you, sir.
Good evening. It's good to be on with you.
Listen, thanks very much. We've been following what you all have been doing with a couple of stories recently, including the new Black Panther Party case, and now FOIA games, you say, being played by DOJ when it comes to Fast and Furious.
Well, it's funny. When they got into the fight with Congress over this fraudulent executive privilege claim, we used the Freedom of Information Act to ask for the documents that they were pretending to withhold under executive privilege. And presumably they knew what documents we were asking for. They waited 20 days, which the law allows them to do, to respond. And at that time they said, well, give us an extra 10 days to respond. And they took an extra 10 days to respond. And at the end of those 10 days, they said, well, we're exerting executive privilege of those documents you asked for a month ago. So now we have to appeal that determination, and then we'll be able to sue, assuming they don't cave and give us all the documents. But I mean, that's typical of the Obama administration. They knew from day one what we wanted, and they knew from day one what they were going to say, but they effectively delayed it a month and a half to, in my view, delay any accounting and any reckoning until after the election, because they're afraid of what the court process is going to do.
Mark Tapscott of the Washington Examiner says one of the things that you all asked for was this Vaughn Index. I know this is something that the House Oversight Committee has asked for as well. This is basically an index that describes in general terms what these documents are so that you understand and can provide an argument as to why perhaps that document does not meet the claim of executive privilege, correct?
Yeah, that's what happens in FOIA litigation and presumably in the House litigation is that once you're in court and you start fighting over documents, generally the government has to provide to you a list of the documents that gives you enough information without divulging what actually is in the documents that allow you to challenge them. So you can find out, for instance, we know this from the Black Panthers claim fight we had. You can get emails, who was involved in the email traffic, what was the general subject matter, what was the date of the email or the date of the document, or their draft memorandum, where their memos floating in and out. You can get a good feel for what was going on, even if you don't get the actual documents. Knowing what you're fighting about is key. And the fight with over Fast and Furious is, more specifically, who knew what and when about that false letter that was sent to the Justice Department in February of last year that had to be retracted. And it's those documents about that decision-making and those lies that Congress obviously is very interested in. They're willing to go to court over, and we're going to have a similar Freedom of Information Act lawsuit. You cannot give this Justice Department any room to maneuver. You see this in the games they're playing with us, the games they're playing with Congress. The contempt for the people's right to know is given the fact that the Justice Department is charged with enforcing our transparency laws across the government.
Right.
They're the worst in terms of being transparent.
Well, that's the thing. So I'm curious, this Vaughn Index, is this a requirement? I mean, are they required under law to produce this?
Well, it's kind of I'm no lawyer. I know
Sure.
I sound like one. But generally speaking, when you get into a fight with the government about documents in Freedom of Information Act litigation, or when you're in a litigation on more direct fighting over a subpoena, you get kind of a log of documents in most cases, not all cases, but in most cases you get a log of documents. And what it does is it helps the court. It's not designed to help the defendant. It's not designed to help the plaintiffs. In some ways it helps the plaintiffs.
Right.
But it helps the court determine what the fight is about. So, they can play games with Darrell Issa, and in many ways it's a political process. I understand that. But once it's in the courts, the Justice Department is going to have to put up or shut up when it comes to executive privilege. There's no doubt about it. All of this pretend executive privilege where the White House wasn't involved but arguably had to be involved in order to assert executive privilege, all those lies are going to fall by the wayside. And I predict you're going to start seeing some of these documents start trickling out, especially as you get closer to the election, because the only reason, in my view, Ken, that executive privilege was asserted anyway was to protect Eric Holder from a criminal investigation. Because the policy of the Justice Department is not to prosecute administration officials over criminal contempt charges if they're withholding documents pursuant to an executive privilege claim by the president. So this is a get-out-of-jail-free card for Eric Holder more than anything else, this executive privilege claim that was, in my view, fraudulently asserted by the White House.
Well, I got to tell you, I've seen a lot of experts on executive privilege, and all of them have said this is an incredibly weak argument that the administration is making here. So you do have to wonder at this point not only what's in these documents themselves, but what is it about even describing in general terms these documents, or who was involved in these emails, that makes the administration so reluctant to produce even something as common as a Vaughn index here. Perhaps there are some names attached to emails that the administration has said should not have been there.
Well, the problem I think they have is that when they presented the false information to Congress, they probably had reason to know at the time that it was false.
Mm-hmm.
There's no doubt. I mean, we've been following it closely enough.
They should have
to know who knew what and when.
Right.
The question is, why is it took months and months and months for the materially false information to be corrected? And that's that delay that I think exposes some officials at the Justice Department to criminal obstruction of justice, lying to Congress and things like that, and any other charge a creative prosecutor could come up with if there was truly an independent criminal investigation.
Yeah.
So I think that's what the nervousness is there. They waited too long after knowing what the truth was to tell Congress what the truth was and to get it corrected on the record. They should have gone to Congress a lot quicker. I mean, if they were operating on the up and up, they would have rushed the Congress as opposed to waiting several months like they did.
Tom, when we talk about this now, especially with the lawsuit that was filed by the House or on behalf of the House Oversight Committee yesterday, I know that we always have listeners who say, we're never going to get the truth about this. We're never going to see these documents. I'm guessing that is not your attitude.
Oh, we're never going to. It's always going to take longer than you want. But my view is you usually get the information or parts of you get more accountability by engaging in the court processes. And you get more documents than you otherwise would if you just left it up to the discretion of the administration. Now, are you going to get it when you want it? No. But we live in a wonderful country where there's a court process that allows a group like Judicial Watch or Congress, frankly, to go in and ask for, get the executive branch to turn over information that it doesn't want to because it's politically embarrassing or could expose criminal activity. There are a few scandals, and I'm not, that have dead bodies tied to them. And I know the media doesn't care about Fast and Furious, but I mean, if this were any other administration, certainly one that was allegedly right-leaning or allegedly conservative or Republican in orientation,
right?
You would be talking impeachment, certainly of the Attorney General.
Absolutely. Tom, thank you again, sir, for coming on the program, and I look forward to having you on again soon. Please keep up the great work.
You're welcome.